Hi, I'm attorney Vincent Davis, and I've been fighting CPS for over 35 years. Through my years of experience, I've gained invaluable insights that I'm ready to share with you. If you're a parent or a caregiver or a relative, we need to talk. I'm offering a new opportunity for you to speak with me on a one-on-one basis. Ask me any questions, and I'll provide you with the insight you need to take steps in your CPS case. Members get everything they need to gain confidence and the knowledge that they need to support necessary to truly fight back. And as a special thank you for attending, I have a special offer just for you. Don't miss out, join us, and let's take that next step together. I'll see you at the question and answer event. Okay, good morning. This is Attorney Vince Davis, and these are my office hours today on Wednesday, December 11th, 2024. Today's topic is trials in CPS courts. I'm going to cover what is a trial, what is not a trial, the value of a trial, and whether you win or lose the trial, why it's important to have the trial for different purposes. All right? At the end of this, there's going to be a link where you can download a document that I prepared. It's kind of a trial cheat sheet for those of you going into the jurisdictional and dispositional trials in your case. And that download is absolutely free. All right. What is a trial? A trial is a court hearing where all parties, through their attorneys, present evidence in the form of witness testimony and or documents to the court for the court to make a decision on the truth or falsity of an allegation, as well as make a decision required under the code by law. All right? That's what a trial is. So if you go to trial and there are no witnesses, that's not a trial. If you go to trial and the social worker's reports are introduced into evidence and no other evidence is presented by anyone else, including you and your attorney, there's a 99% chance you're going to lose. Because the judge has to make a decision based upon the evidence before him or her. Evidence. Let me tell you what is not evidence. Your attorney or any attorney arguing to the judge based upon the social worker reports. You're going to lose. The other day I did a trial and this county counsel who represents a social worker says to me, why don't we just argue that issue to the judge? And I couldn't help but kind of chuckle because she knows that if we just argue it with the judge and I don't present any evidence, I'm going to lose that argument. All right. So in this particular case, it was a sub issue within a larger trial. And everything had been settled and resolved except for this one issue. And she says to me, why don't we just argue it to the judge? Now, attorneys that are probably not that experienced would say, oh, okay, because they think their oral argument to the judge is going to do something or have some effect. The bottom line, if you argue without presenting evidence, you're supposed to lose. Okay? So let me tell you what is not a trial. You show up on the date of trial and you think you're going to have a trial. And the judge calls the case, everyone states their appearance, and someone says, well, judge, we're just going to argue it. Notice that before they argue it, the social worker's attorney puts all of the social worker's reports into evidence. Okay? And it's done kind of nonchalantly. Once that's done, each attorney gets a chance to argue an issue or issues in the case. All right. And then at the end of the hearing, 90% of the time, the judge is going to rule in the social worker's favor. And you're scratching your head like, how could this have happened? It's simple. It happened because you didn't really have a trial. What you did, and I see it a lot, what you did is you let your attorney argue without putting anything into evidence, like calling witnesses, like cross-examining the social worker, like subpoenaing witnesses or other documents into court to prove something's true or false. Okay? So, if you're going to have a trial, you better make sure that you and your attorney have witnesses that can be called, that can be put on the stand, and that can testify. All right? So that's what a trial isn't a trial, but they just call it a trial. What they're doing is just saving time and disposing of your case, and you're going to take the L, the loss. Let me tell you the value of a trial. I'm going to tell you first a story that happened to me recently. It's happened to me many, many times over the years in many, many counties and places in the United States and in California, especially in California. There has been so much evidence written against my client, and it seems overwhelming that I could possibly win, right? So when you tell the attorneys and the judge, hey, I want to have a trial, they kind of look at you sometimes and roll their eyes like you're going to win. I mean, you're going to lose. So why are you doing this? Well, there's a lot of reasons why to have a trial. Because unless you put into evidence certain witnesses and documents, the judge is going to have the social worker's view of the case, because that's the only thing the judge has in front of him or her is the social worker's facts and evidence. So in this case that I did, I called witnesses at the jurisdictional and dispositional phase of the case. I did not prevail on the jurisdictional phase of the case, but I prevailed on the dispositional phase of the case, and I got the children home to the mother. And the reason why I did that is because throughout the case, I was able to persuade the judge of my view of a particular statute in California, the dispositional statute. Sometimes I get the feeling that county councils, prosecuting attorneys, don't understand what the law says. And the law says even if the jurisdictional phase of the case is lost by the parent, in other words, the allegations are true, the social worker still has to prove by clear and convincing evidence that you are a substantial danger to the child, and has to prove by clear and convincing evidence that there's no less restrictive alternatives. If they don't prove that, both of those, the children are supposed to be returned to your home. This case I did was with a county council that's been around for years. And I had the same issue with her many years ago, that is the standard that the court has to use. And what county councils try to do is, I think they're trying to convince the judge that the kid shouldn't be returned home if they prove by a preponderance of evidence that you're a risk. Now, there's a big difference between that and clear and convincing evidence that you're a substantial danger. If I look at you wrong, if I'm a parent and I look at you wrong, the wrong way, the kid the wrong way, I could be a risk. But I have to be one bad MF to be a substantial danger to the child. Not just danger, substantial danger. Okay? When you look at statutes and look at laws, Words have meanings, okay? And substantial danger does not mean a risk. They're defined differently in California law. So not to get the child back at the dispositional hearing, they have to prove by clear and convincing evidence, not a preponderance, which they used at the jurisdictional phase of the case. They have to prove by clear and convincing evidence that you're a substantial danger. You got to be one bad dude or one bad mama to be a substantial danger to a kid. Okay? I don't care what the allegations are. All right? The other thing they have to prove, and this really helped me in my case when I did this trial, they have to prove by clear and convincing evidence there are no less restrictive alternatives, right? When I was cross-examining the social worker, I said to him, tell the judge, what less restrictive alternatives did you consider? What do you mean? Now, that right there told me that he wasn't familiar with what the law said. He was just being a social worker, loosey goosey, and we're going to make decisions based upon our gut level and the fact that we don't like the mom. Well, that's not what the law says. So I pointed him out in the statute. I said, have you ever read this before? No. Maybe I have. I'm not sure. Well, it says that you have to consider less restrictive alternatives, and you just told us that you didn't consider any less restrictive alternatives. Now, right there, technically, I should win the case. He didn't fulfill his burden of proof under the statute. Okay? But I had to go further with this judge, and I had to propose less restrictive alternatives. Here's a less restrictive alternative that people never think of. Something called family preservation. Almost every county and state, especially in California, gets federal money to provide family preservation services. But you never hear anybody talk about that because the counties get millions of dollars from the federal government to provide services to you to keep the child in the home, no matter what you did. Let me give you an example. I have a client right now that gets family preservation services. The child is in her home, And this is what happens. 3 times a week, about 4 people from something called Family Preservation RAP team goes out to her home, gives her individual counseling, gives her conjoint counseling, gives the kid individual counseling, and gives her parenting classes and homemaking classes, how to keep your house clean and organized. Well, if they provide those services with her, they're helping her keep the child safe while keeping the child in the home, while keeping the child around his or her friends, while keeping the child in the same school, right? A less restrictive alternative. Here's another less restrictive alternative that I never hear talk about. Hey, judge, you don't have to take the kids out of the mom's home if you think this is a close call. Because I have relative grandma who came here from Mexico who is willing to live at the home and make sure the kids are safe, to live at the home with the mother being present and the kids being present. Oh, Mr. Davis, that's a great idea. Remember, the social worker never considered any less restrictive alternatives. So are there family friends? Are there relatives that could come live with your client or come live with you in order to make sure that the kids are safe, to give the judge that extra level of security? Because let's face it, judges in these cases are responsible for keeping the kids safe. All right. And over the years, I've seen judges get in trouble for returning a kid over the department or the CPS's objection, and then something happened. All right. So judges want to be secure in the decisions they make. I mean, if I were a judge, I'd feel the same way. If you were a judge, you'd probably feel the same way as well. Okay. So that's one of the reasons why you want to have a trial. You might win. Number 2, you want to set up a good appeal. If you don't have a trial, there's no evidence on your side when you appeal the case. because all the evidence was for the social worker. It was all her reports. So you got to call witnesses to somehow um, show that the social worker was incorrect. You know, I once had a case, and for me, it's not unusual. The social worker said my client's therapist said ABC. All right, and my client kept telling me that's not true. That's not true. And I said to my client, I said, "How do you know what the social worker and your therapist talked about? You weren't there." She told me the reason why I know is because the therapist told me she's never met or talked to or text with or emailed the social worker. Now, remember, the social worker wrote in the report, the therapist said ABC about the mother. So I subpoena in the therapist. I asked the therapist, have you ever met the social worker? No. Have you ever communicated with the social worker in any way? No. And just to make it clear, I said, you've never talked to the social worker on the phone? No. You've never emailed with the social worker? No. You've never texted with the social worker? No. Smoke signals? I'm just kidding. The social worker never communicated with the therapist, but yet wrote and in a report and testified that she had spoken to the therapist and the therapist told her ABC. Okay. You see how important that is? And sometimes I get the feeling, social workers don't tell me this, but I get the feeling that they'll put stuff in a report like that because they know that you or your court appointed attorney will never subpoena in any witnesses to contradict what they say in their reports. And if you don't do that, you're going to lose in 9.9% of the cases. Okay? So that is the reason why you should have a trial with witnesses and a trial with exhibits that are subpoenaed in. Like maybe it's the medical records, maybe it's the therapist records, maybe it's the dental records, maybe it's the school records. All right. You are going to get information that you're going to need. I just was involved in a case where the kid was interviewed by the police before this case started. Okay. And one of the things that helped resolve this, sort of in my client's favor, was the police videotapes. They didn't actually say what the social worker was purporting they said. And there were hours of videotapes. Okay, so sometimes you got to subpoena those videotapes in. And sometimes police departments want to give you a hassle about getting those videotapes. All right, so you have to do some investigation, you have to do some discovery, and you have to bring these documents to the court. One of the things I think that impacted the case for me was something very non-legal. I had subpoenaed in or gotten all the videotapes. I had them transcribed because in California, videotapes are not admissible unless they're transcribed. Okay, you and your attorney should talk about that. But I had all these videotapes transcribed. It cost a couple $1,000s. Social worker's attorney never thought I'd do that. Well, I did. And then I hired a litigation support company to come out and set up a laptop and to connect all the computer screens in the courtroom and a big giant TV screen so that I could play the videos for the judge. Now, before we started that, the social worker and her attorney knew that I was serious and that I had found stuff in the videotapes that was going to help my client and make her client possibly look bad, or perhaps not even telling the truth, or perhaps being biased. Okay? So, one of the issues in this case was, from our perspective, the child was interviewed by the police and said ABC, which actually helped my client. She was interviewed again during the same session, which lasted hours, which is a whole nother issue. But she said ABC. That helped my client. And then there was some missing videotape. And according to the kid would have testified that The police officers said to her, "Well, if you say XYZ instead of ABC, we're going to give you some type of reward." And I won't mention what the reward was, but that she was going to get a reward, something she wanted. So then there's a videotape of the kid saying, "Oh yeah, XYZ," which hurt my client. But nobody ever disclosed to the judge in any social worker report that when they first asked the kid said ABC twice, which was favorable for my client, and in my opinion, tended to show that the allegations the social worker was trying to say were not true. So it gets kind of complicated, or you have to drill down to prove certain things. But look, if I don't get the transcripts prepared and served on everyone, they know my videotaped evidence from the police is not admissible. All right. If I don't bring a big TV screen and hook up all the computer monitors in the courtroom and to a laptop and to play videos, guess what? The judge will never look at those videos. So I was prepared. And that is one of the key things that you have to concentrate on when you're going to do a trial in CPS court. Preparation, preparation, and preparation. Always try to sit down with your attorney and try to prepare and have him or her prepare with you. This may be the most important hearing or in trial and lawsuit of your entire life. It could lead to you losing your children permanently, if not for 6 to 12 months. So prepare. As I mentioned at the beginning of this show, at the beginning of our show, we're going to have a handout. There's a free handout on how to prepare. As a checklist I prepared, about 5 or 6 pages, how to prepare for a contested jurisdictional and dispositional hearing. Okay, some of it is common sense, some of it isn't. Some of it is things that you probably never would have thought of, but then it's like, oh, that makes sense. So take the time out if you're having any type of trial and read this checklist. It'll be well worth your while, and I'm sure your attorney will be impressed. Okay, so that's the end of the office hours for today, December 11th, 2024. If anyone who's watching or who sees this has any questions, give us a call at our hotline number, 888-888-6582. That number is in the bottom right-hand corner of this video screen. All right. So until tomorrow in our office hours, everyone stay safe and good luck with your cases. Hi, I'm attorney Vincent Davis, and I've been fighting CPS for over 35 years. Through my years of experience, I've gained invaluable insights that I'm ready to share with you. If you're a parent or a caregiver or a relative, we need to talk. I'm offering a new opportunity for you to speak with me on a one-on-one basis. Ask me any questions, and I'll provide you with the insight you need to take steps in your CPS case. Members get everything they need to gain confidence and the knowledge that they need to support necessary to truly fight back. And as a special thank you for attending, I have a special offer just for you. Don't miss out. Join us, and let's take that next step together. I'll see you at the question and answer event.